Insist you to keep your cameras on. Goes on set. Let's get started. So, good morning, everyone. Hope you guys are doing well. My time zone is appropriate. Hope you guys have corrected your time zone and pulled up your socks for the examination that you're going to write. I might not want to repeat this throughout. Insist you to keep your cameras on. What we are going to do is we've already revised a couple of topics in the last session itself, if you remember. So don't ask us what you taught in the morning itself. We don't remember. And you're asking what you've revised probably earlier, whether we remember or not. You're assumed, you're deemed to remember that. All right. Nevertheless, what we're going to do is we're going to spend probably 40-45 minutes on quickly looking into those chapters which we had not touched upon in the previous sessions. All right. In the previous revision, when we had not touched upon those, that we are going to touch upon now. And 15 minutes at a very fast pace, we are going to run through whatever we revised earlier. Possible, 100% possible. Just pay attention. 1 hour. Give the best time of yours. Let's get started with the session. Let me know if the screen is visible. By the way, what all was pending in the last session? Anyone? Don't know. Relax.
General clause.
Relax. I don't want to take the attention of that. You please fully just listen to. I will do whatever is required. All right. Let me know if the screen is visible. Yes, no, respond.
Yes, sir.
Yes, sir.
Yes, sir.
Perfect. Insist you to keep your cameras on. So what we are going to do is Civil Instruments Act, General Clauses Act, and Interpretation of Statutes. These are the 3 chapters that were open in the last session. Of course, negotiable was discussed, but nevertheless, I'm going to touch upon at a quick pace so that you hang off the chapter once. Can I start?
Yes,
Yes,
sir.
sir.
Yes, sir.
Wow. Look at the energy.
Yes.
I think my energy.
Yes,
Yes,
sir.
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 Yes, sir.
Let's get started. All right. So Negotiable Instruments Act 1881 was the topic, wherein we see quickly what is the whole of negotiable instrument means. It is an instrument which is going to enable transferability from one to another. We didn't understand detail. No problem. Section 13 gives the definition. Definition of negotiable instrument. Am I audible? Yes, no?
Sir, your voice is
Bit
loud.
of a lag.
Yes, give me a second. Better now? Yes.
Better.
Is it better
Yes,
now?
sir.
All right, perfect. So negotiable instrument has been defined under section 18 as promissory note, bill of exchange, and checks. The important thing. Promissory note, bill of exchange. Where is the definition coming? Very important. It's coming from section 13. But does my answer end there? No. If you just write these 3 points, you're not going to get marks. What my answer consists of, you have mentioned that it has to be payable either to the or to the bearer. If you don't mention this, then your answer is incomplete, because the entire negotiability is driven by these 2 words, to the order, to the bearer. We went on to understand. Audible? Surti?
Sir,
Yes.
the video is.
Yes, sir. There is bit of lag.
There is some lag, sir.
I'm extremely sorry. Just give me a second. Let me fix this. Just give me a second, Prince. Is it better now? Yes, no, audible?
Yes, sir. Sir,
Yes, sir.
Audible, sir, but
Video-
video is.
Allow me a minute. Allow me a second. Just a second. All right. Now is it better?
Yes.
yes.
Perfect. Am I audible? Am I visible?
Not
Not
visible.
visible.
Audible.
Visible. All right. Am I audible?
Yes, sir.
Yes, sir.
Yes, sir.
Now am I visible?
No, sir.
No,
I
sir.
haven't
No,
switched. I haven't switched on my camera yet. Hold on. If anyone would have said a yes now, I would have got a heart attack. How is it possible? Anyways. Is it better now? Yes,
Yes, sir.
audible?
Yes, sir.
Yes, sir.
Perfect.
Yes, sir.
Yes, sir.
So section 4 defines the word promissory note. What is promissory note? It is an instrument in writing, very important. Don't forget, it can't be verbal. Promissory notes, again, one of the MCQs, I would not be surprised if they ask that the note, the instrument is verbally executed, or rather verbally agreed upon. It can't be executed verbally agreed upon between the parties. Can that be considered as a promissory note? The answer is no. It has to be an instrument in writing containing an unconditional undertaking. Very important. Here, if you see, it is in writing wherein I'm giving a unconditional undertaking. When it comes to a bill of exchange, I'm giving an unconditional order. Difference between the words. All right. When it comes to a promissory note, it is always unconditional undertaking. When it comes to bill of exchange, it is always unconditional order. As simple as that. All right. In promissory note, I'm promising that I'm going to pay a certain sum of money. To whom? To any of the persons that you ask for. When it comes to bill of exchange, I'm promising, or rather in a bill of exchange, I am ordering you to make the payment. To whom? Either to me or to any other person that I ask you to pay. As simple as that. Under section 4, section 5. Then we went on to understand very important section 6, which defines check. What is check? Check is a bill of exchange. Don't forget. Check is a bill of exchange which is drawn on a specified banker and not expressed to be payable otherwise than on demand. That means it is only on a specified banker. Therefore, the drawee is going to be your banker. Drawer is going to be you. Payee is going to be the person who is supposed to receive the money. Don't get confused. I repeat, drawer is the person who drafts the check. Drawee is the banker on whom the check is being drafted, and payee is the person who's going to receive the money. Understood? Yashaswini, there in the session. Not expressed to be payable, otherwise than on demand. Very important. Otherwise, it also includes your electronic check or electronic image or a truncated check, and it also includes your check in electronic form. Understood? Next point. Acceptor for honor. Now, what is this acceptor for honor? Some third party who is coming in, like your Bahubali, suddenly for out of no reason, he comes into picture. Who's going to help in a scenario where the instrument is being dishonored? All right. I repeat, what is this? Sir, it is a situation in which the drawer or the drawee, or rather in our scenario, the payer says, sir, I have no money. I'm sorry, I have no money. Now, what is going to happen in case if the other person does not honor it? It will be returned as dishonor on non-payment, or non-payment is going to be the scenario. Now, someone has to come in to ensure that this does not get dishonored. What will happen if it gets dishonored? Again, the cycle starts. The cycle starts again from the beginning. I don't want that to happen. Therefore, suddenly, out of blue, some Bahubali comes into picture and that person says, don't worry, I'm here. I will take care. That person is called as acceptor for honor. All right. This person is going to take care of the instrument which is about to be dishonored. This person is called as acceptor for honor. Let's quickly run through the language. It is an undertaking by a third party to accept and pay a bill of exchange that was dishonored either by non-acceptance or by non-payment by a party on whom it was drawn. It is also called as acceptance supra protest. Note this phrase, because in examination, they are not going to ask acceptor for honor. They are going to ask, write a short note on acceptance supra protest. Expect this as a question for 4 marks. They are going to play around. Paper is not tricky. They're just going to trick around with these games. I hope I'm clear, everyone. Understanding? Yes. Next point. Rights and liabilities of an acceptor for honor under section 111, 112. Very simple. Whoever is the acceptor for honor, he is binding himself to all the subsequent parties. Above all, he has the right to recover the money from the person on behalf of whom he is accepting. As simple as that. 2 things. One is the right. What is the right? On your behalf, if I am accepting, I have the right to recover the money from you. Second thing, I am making myself responsible for everyone who is liable to be paid by you. All right. You were supposed to pay them. Instead of you paying them, I am coming into picture. I will take up the responsibility. Understood, everyone? Yes, crystal clear. Next point, holder. Holder is a person, very important, who in his own name is entitled to receive or recover the money. Very, very important. All right. For any instrument where a person in his own name is entitled to recover the money is called as holder. Classic example, your father has given you a gift. Blank check. Do you remember? Same example. Can you sue him? Answer is yes, you can. All right. However, are you going to be a holder in due course? The answer is no. Are you a holder? Yes. Are you a holder in due course? Answer is no. Why? Because for holder in due course, you must do it for a consideration and it has to be in good faith. I hope I'm clear, everyone. Are you a holder? Answer is yes. For those of you who didn't understand the example is very simple. Your dad has given you a blank check. Now you seeing the blank check have gone blank and have entered as many zeros as possible after number 1. Now what has happened? Suddenly this bounced. And you're so frustrated that you filed a case against your dad. the one who has given you the blank check. Is it going to be tenable? Answer is yes, because you're going to be the holder. But are you a holder in due course? The answer is no. Why? Because you're not going to get this for a consideration, first thing. Second thing, you're not going to get this in valid title. I hope I'm clear, everyone. Understood? Understood, everyone? Crystal clear with the concept? Yes. Next point.
Yes,
Sir, a person who steals or finds a bearer is not the holder. Very important, because he is just holding it. He is not entitled to receive the amount. Very important. Let's assume your blank check was lying in the drawer. I've stolen it and I have tried to encash it. Tomorrow, can I have can I ask for any of the rights in it? Answer is no. Why? Because I am not entitled to receive this amount. I hope I'm clear. Holder in due course is a person who for a consideration has become a possessor. Very important. There is a requirement of
Sir.
consideration.
Sir, your voice
There is
is
a holder in due course. All right. Very important.
Sir.
You're not audible, sir.
Now is it audible? Now am I audible? No.
Yes,
Just
sir.
okay, second. Now is it better? Yes. No.
Yes,
Yes,
sir.
sir.
Yes.
I'm extremely sorry. Nevertheless, I will make it up for it. Audible? Yes.
Yes, sir.
Yes, sir.
Perfect. So, two important things when it comes to a holder in due course. The first one, you will have to remember that it is for a consideration. The second thing that you will have to remember, it is for a good title. It is in a good faith. All right. In case if any of these are missing, then you do not remain holder in due course. Now, sir, what if you are a holder in due course? You become the Abhimanyu. Am I audible?
Yes.
Am I audible?
Yes, sir.
Who is this Abhimanyu? He's the only person who can enter the Chakra view. Do you remember somewhere some faculty might have taught
Yes,
the
sir.
mythology?
Yes.
The same
Yes,
person
sir.
is now revising. He's just saying that you become that Superman, that Batman who is going to have the power to purge all the defects. What is the language that we use? P-U-R-G-E. Purge all the defects. Even though the instrument might be defective, but the moment it passes through you, you have all the entitlements to remove the defects in it. And once it passes through you, it becomes a valid instrument. Only exception is forgery. Only exception is forgery. I hope you're able to appreciate that. You may or may not have read everything, but at least you're able to recall. Great. Let's continue. Next point. Types of instrument. Instrument can be bearer or order instrument, inland and foreign instrument, inchoate and ambiguous instrument, demand and time instrument. Chinmay there in the session, understanding? Spurti, Apurva, Anjana, Deepa?
Yes, sir.
Yes,
Yes,
Sana,
sir.
Sona?
Yes, sir.
So, bearer and order instrument, bearer means whoever has it, enjoys it. Amazon voucher. Order instrument, only the person whose name is mentioned is the person who can enjoy it. That becomes your order instrument. Inland instrument, foreign instrument. Foreign instrument, it is called as an inland instrument if three conditions are satisfied. Made in India, by a person in India, drawn on a person in India. If all these three conditions are satisfied, then it becomes an inland instrument. If any of these are missing, then it becomes a foreign instrument. Inchoate instrument, something is incomplete just as much as you guys are. Can I get a little energy? Yes. So
Yes.
inchoate instrument is an incomplete instrument. Something is missing in it. What is ambiguous instrument? As much as our lives are complete confusion, Chitrana, ambiguity is there. What is the whole point? Sir, I don't know whether it is a bills payable or whether it is a bills of exchange. Are you I'm sorry, whether it is a promissory note or whether it is a bills of exchange, I'm not really sure of it. That is called as ambiguous instrument. Sir, how is it possible? What goes around comes around is the scenario. All right, A started, goes to B. B gives it to C. C gives it again to A. Now, what has happened? I don't know. I have the instrument. I am the one who started it. I am the one who's holding it. Now, what is it? Is it a promissory note or is it a bill of exchange? I don't know. That's the whole point of ambiguous instrument. I hope I'm clear, everyone. All right. Demand and time instrument. Demand instrument, only when you demand, you get it. Example, check. Time instrument, you're going to get this only after the expiry of the period, which has been mentioned in the negotiable instrument. This is called as time instrument. Then we went on to understand types of endorsement. What is endorsement or endorsement? It is one and the same. First thing, don't get confused. Endorsement and endorsement is one and the same. When the holder of a negotiable instrument is transferring the rights in a negotiable instrument to another person for the purpose of negotiation is called as endorsement. Very important. It is done through a slip. If a slip is attached, that slip is called as a launch. All right, that slip is called as a launch. Am I clear, everyone? Yes. Now, when it comes to types of endorsement, you can have an endorsement in blank, you can have an endorsement in full, you can have a partial endorsement, restrictive endorsement, conditional endorsement. Often asked in examination is, what are types of conditional endorsement? First one, sans recourse endorsement. Once it is out of my zone, it will not come back to me. I'm not going to hold myself responsible for it. Those are called as sans recourse endorsement. We've discussed again a couple of examples. I'd shown a live example if you remember. Anyone? Quick. Any example? Any example? Somewhere we have come. I'm sorry, who was it? Who was it?
Me, sir. Harshit.
Good. What was it? I'm sorry. Can you
Sir,
repeat?
we went to the RBI website.
Brilliant. It's called TREDS. All right. Trade receivables, which were discounted. Do you remember? We had seen it on the portal, which shows that that was one of the instrument which was sans recourse. Once it is out of my hand, it will not come back to me. I will not be liable for it. Now, apart from that, you have your liability dependent upon contingency, facultative endorsement, and your sans phrase endorsement. I'll not get into the details. Let's quickly go to the maturity date. Again, latest attempt. By the way, mind you guys, last attempt, there was a question of 4 marks only on maturity days. 4 marks on maturity date. I am sure each one of you will be able to get that. I am not having any second thoughts on this, because we have seen what blunders you do if it is end of the month, if it is 28th, what happens, and a couple of things that we revolve around that. Do you remember we've discussed this? Yes? No?
Yes, sir.
Yes, sir.
Who can enter into a contract? Every person who is capable of contracting, every person who is doing it through an agent. Can a minor become a party or to the negotiable instrument? Answer is yes. A minor can be a part of negotiable instrument. He can hold everyone responsible except for himself. Except for himself. Again, live example that we have discussed during the session itself. Your minor bank account, if you remember. All right. Then discharge of endorser's liability. The endorser is not going to be liable if the subsequent parties or any remedy of that endorser has been destroyed. All right. If you destroy the remedy of the endorser, then I will not be liable for any of the liabilities which can arise later on. All right. In simple example, let's assume I've given it to Anjana. Example, John Rosario. Do you remember the same example, John Rosario, or somewhere
Yes,
where I've
sir.
scratched the name? All right. I've scratched the name, and the moment the names are scratched, I am impairing the remedy of the person, and therefore the moment the remedy is impaired, that the endorser is discharged of his liability. Do you remember the example? Yes. Next point. Acceptance of bill drawn in fictitious name. Example, Ravan. Do you remember? Yes. I've drawn the bill in the name of Ravana. You've accepted the bill. Tomorrow on the due date, you're saying, I'm sorry, I can't take the payment. Why? Because the bill is drawn on Ravana's name, a fictitious person. Why did you accept? Why did you accept? That is nothing but section 42. All right. In case of a bill of exchange is drawn payable to the drawer's order in a fictitious name and is endorsed by the same hand on the drawer's signature, it is not permissible for the acceptor to allege that against the holder in due course that such name is fictitious. All right. You can't later on say that the name is fictitious. I will not make the payment. Why did you accept at the beginning? That's the whole point. Understood, everyone? Yes. Next point. Material alteration. Any changes without the consent of the prior parties is called as material changes. It could be in terms of date, time, amount, place, etc. What is asked in examination often is what is not material changes or material alteration. Am I audible? What is non-material alteration is often asked in examination. So the first one is filling the blanks, converting blank endorsement into full endorsements, crossing of check, converting general crossing into special crossing, or any endorsement or alterations with consent will not be called as material alteration. Understood? There in the session?
Yes,
Yes,
sir.
sir.
All right. Stolen or lost instrument. The moment an instrument is lost, all right, the holder will not get any valid title. However, if it passes through your holder in due course, he is going to get a valid title. As simple as that. Why? Because there's only one thing which the holder in due course cannot remove, and that is forgery. Apart from that, even though it is a lost instrument, let's assume Pradeep is having a blank check. I've stolen it. And after stealing it, I have given it to Anaga. Now, Anaga has taken it in good faith. Can Pradeep later on say that this entire transaction is not right because it has been stolen? Answer is no. The moment it passes through Anaga, it becomes a valid instrument. Anaga is a holder in due course who can purge all the defects. Now, all my emotional friends, don't get emotional. Law will bring Pradeep back to the favorable position somehow. Don't worry about that. All right. Negotiable instrument without consideration under section 43. Is it possible? General piece of law? No. General piece of law? No. You cannot have a negotiable instrument without consideration. There are only 2 exceptions. One is called as the accommodation bill, kite bill, if you remember. All right. The second one is called as failure to perform or partial performance. The next one is holder's right in case of lost instrument. Let's assume you being you have a check and you've lost it. Now what? Do you have the valid title? Can you go ahead? Do you have the right to ask for another duplicate? Answer is yes, you can. Provided you give the indemnity, provided you give the assurance that tomorrow, in case if anything happens, I will be responsible for it. After that, also, if I say no, I'm not going to give anything to you, you can force me to give the instrument. All right. Even after request, if I'm refusing, then you can compel me to give the instrument, the duplicate instrument. This is coming under section 45A. Then we went on to understand discharge of instrument. When will the instrument come to a closure? Payment in due course, by release, or by cancellation. Any of these three happening, the instrument will come to a closure. Sleepy, there in the session?
No, sir. Yes.
There in the
Yes,
session.
sir.
Yes, sir.
Thank God they're in the session. What is this? Yes for? I didn't understand. All right. Now, if the drawee is given more than 48 hours to accept, all right, let's assume you and I have a very good rapport. Now, based on this, I'm giving you, you will take your own sweet time. I know you take 72 hours. Give me your acceptance within 72 hours. If I do anything beyond 48 hours, all my prior parties will be discharged of the liability. Where is it coming? It's coming from section 83. Understood? Dishonor by non-acceptance. This is a scenario where the instrument is not being accepted or has been dishonored because of an acceptance. This will arise into picture. This will come into picture as dishonor by non-acceptance. Now, note, this is a scenario where the instrument is being dishonored because of non-acceptance. Where, what are the situations? Drawee is incompetent to contract anymore. He is giving a qualified acceptance. The presentment is excused and bill is not accepted. Any of these scenarios come into picture, then it will be called as dishonor by non-acceptance, section 91. Dishonor by non-payment. For those of you thinking, sir, this is not something that we have discussed, don't worry, this is not there in your syllabus. I'm just giving you a quick passing reference. Understanding, don't take big tension for this, relax. Next one is dishonor by non-payment. Section 92 talks about where there is a default in payment on the due date, that will be called as dishonor by non-payment. Most important thing, notice of dishonor. Whenever there's a dishonor, you have to ensure that you give a notice of it to the parties involved. Sir, I forgot to give the notice. That means that party is discharged from their liability. There are a few scenarios, very, very important from examination perspective, section 98. There are a few scenarios. Anjana, there in the session. Spurti there.
Yes,
Harshvardhan.
Yes, sir.
Sir.
There are a few scenarios in which this notice of dishonor is not required at all. You don't have to give a notice at all. What are the scenarios? Let's quickly see through. The first one is where I am myself told, don't give me a notice. Second, where I've countermanded the payment, where the drawer himself is saying it's okay, keep it aside. Where I will not suffer any damage, even if I don't give the notice, still I will not suffer any damage. In that case, you don't have to give any notice. All right. Next one, where the party entitled to notice cannot be found, where you're trying to search him, but that party itself is not available. Whom will you give the notice? Are you guys understanding? Yes. The next scenario, where the notice is caused by unavoidable, the omission is caused by unavoidable circumstances. Classic example, COVID. I can't give a notice. Even if I have to give, I can't give. To whom will I give? How will I give? That is the whole point, because of the unavoidable circumstances. Acceptor is also the drawer. Nothing but a scenario where an ambiguous instrument could arise. The notice promises to pay unconditionally, where I've told, sir, even if you don't give the notice, I will still make the payment. That is a scenario. Don't give the notice. As simple as that. Understood, everyone? Next, discharge of parties. When will the parties, two important things. One is discharge of instrument. Second is discharge of party. Don't get confused in examination. Discharge of party means that party is no more there in the picture. The instrument might still be valid. The instrument might still be existing, but the party has moved out of the transaction. Understood? Classic example, cancellation, discharge of the secondary, law, operation of law, where I'm allowing more than 48 hours, all the prior parties would be discharged. Do you remember? Just now we've discussed. All right. Non-presentment of the check promptly, not taking any qualified acceptances or any material alteration. These are the scenarios where the parties would be discharged. The instrument is still valid. It is still tenable, but the parties are discharged. Last one. All right. Penalties in case of dishonor of checks due to insufficiency of funds under section 138. All right. Check bouncing is what we are talking about. Understanding? Don't use this language. Your wide smiles and laughters are more than enough to bring the point that you cannot use this language in examination. If you use, and if some cranky evaluator, thank God it's not me, some cranky evaluator gets a paper, trust me, he's going to carry this image throughout the paper. Don't mess around. Don't mess around even after knowing about it. All right. So penalty in case of dishonor of instrument because of insufficiency of funds under section 138. What does it say? Where any check drawn by a person on an account maintained by him, very important. We've solved a case study, if you remember, where promoter had issued a check of the bank, of the company. Was it his account? Answer is no. It was the promoter who had issued the check of a company. It was not the account which was maintained by the company. It was rather it was the account maintained by the company and not by the promoter. Can you hold the promoter responsible under section 138? Answer is no. Can you hold the promoter responsible under section 138? Answer is no. We have solved a case study during sessions, if you remember. All right. Because the account is not maintained by him with the banker. It is the company which is maintaining the account with the banker. All right. When there is a payment due to another person for the discharge of your debt, that instrument has been returned by the bank unpaid, either because there is a standing credit to the account is not sufficient. Let's assume you have to pay 10,000, but in your bank account, you have only 5,000. The amount which is standing credit to your account is insufficient. Or second, where the amount arranged to be paid is from that account by an agreement made with the banker lesser or exceeding that. What is the meaning of this? The second situation is where company clearly says, don't make any payments more than 10 lakh rupees. And let's assume I've issued a check of 11 lakh. It will come back. Why? Because the banker is not going to make a check payment of 11 lakhs. Are you guys understanding why? Because I am myself given him a standing instruction. That is the language we use. Understanding? In this scenario, there is a committance, there is an offense which is committed and shall be punished with an imprisonment up to 2 years or with a fine which shall extend up to twice the amount of the check, or with both. Compoundable or non-compoundable? Compoundable or non-compoundable?
Compoundable.
Those who were there in morning session, at least you should be in a position to answer. Just today we have discussed. All right. Next, non-applicability of this section. This section is not going to apply. Or rather, this entire thing is not going to apply unless the following conditions are satisfied. What are the conditions? First one, check should be presented within the valid period. All right. Second, demand for the payment through the notice. Whenever the check bounces, you can go ahead. Whenever the check is returned because of insufficiency of fund. Those of you who know this is wrong but not able to come up with the language, this is also a problem. You know it is wrong, but you don't know what to use. This is also a problem. You know it is wrong. You know you can't use check bouncing, but you don't know what to use then. Where the check is returned due to insufficiency of funds. All right. In that scenario, you have to give a notice to your prior party. When within 30 days of the receipt of information, you have to give a notice. Understanding, everyone? Yes. Now that person is going to get 15 days. After 15 days also, if he doesn't make the payment, please go ahead and file a case under section 138. Understood, everyone? Crystal clear with the concept? First, give him a notice. How many days? Within 30 days from you getting to know, please give a notice. The moment you give a notice, he has 15 days. Within 15 days, if he does not make the payment, please go ahead and file a case against him under section 138. If it is a company, what will happen? Every person who is extremely important. Every person, if the person committing the offense is a company, every person who at the time of the offense was in charge of and responsible to the company for the conduct of the business shall be deemed to be guilty of the offense and shall be liable to be proceeded against and punished accordingly. Very important. Whoever is in case of a company, I can't arrest the company and take them to jail. I hope you realize I will have to take the person. Now, who's that person? Every person, whoever is responsible. That person will be blocked. That person will be booked rather. Understanding? However, there's one exception. The only exception is where you're becoming a director of the company because of some arrangement, or where you are a lender, where you are a financial institution and you are sending a person on the board of the company so that he can represent you. That person cannot be taken to the jail. I hope I'm clear. Why? Because, sir, he's not even your employee. He is not even insider. He's just come on because he is employed somewhere else. Let's assume I'm working for SBI. SBI has asked me to come on board because SBI has given a loan of 1 crore. They want to check how is it being used. To ensure that it is being used appropriately, they've sent me. Now, because you've done a fraud, do you think they will take me along with you? Answer is no. We have discussed this in length and breadth. This brings me to the end of negotiable instrument. I hope I'm clear, everyone. General Clauses Act, simple act, 1887. What is this act all about? The objective of this act is to shorten the language. Again, please expect this as a question in examination. What is the objective of General Clauses Act? First one, to shorten the language. Second one, to provide as much as possible uniformity of expression. To state explicitly the rules that you have to use for interpretation and construction. And the last one, to guard slips and oversights by the importing into every act containing common forms or clauses. What is the meaning of this? By mistake, if they have forgotten to define, you can't say that there is no meaning. Please go read the General Clauses Act. I've given the meaning there. Understood, everyone? Yes. Next point. Application to the act. This act applies to entire India. and it also applies to Jammu Kashmir. Am I right? This act applies to entire India. It also applies to Jammu Kashmir. General Clauses Act.
No.
Sir, it doesn't have any territorial clause.
What are you guys thinking so much? General Clauses Act is like Hutch dog. It follows wherever the owner goes. Do you remember the same discussion that we had? All right. Wherever the owner goes, the person, the Hutch dog is also going to follow. The same way General Clauses Act also follows wherever the main act follows. There is no territorial clause when it comes to General Clauses Act. Why? Because let's assume if the entire Finance Act of 1994, which deals with your service tax, is not applicable to Jammu Kashmir, then can I read General Clauses Act in Jammu Kashmir for service tax? How is it possible, sir? When service tax itself is not applicable, how can you read General Clauses Act for service tax in a state which is not even having general service tax? Am I making sense? Am I making sense? Yes.
Yes, sir.
So very important. There is no territorial clause when it comes to the application of the General Clauses Act. Next, there are a few definitions. Then we saw the difference between the word shall and may. Can't forget section 3, subsection 1. Company may be formed for the purpose of lawful business, except, or rather, in case of private company, 2 or more, public company, 7 or more, 1-person company, only 1. All right. So, classic scenario where may has to be interpreted as shall. Ideally, not required. If you ask me personally, there's not even a requirement of reading may there as shall. But just in case, if you still want an example, I've already given one. All right. Now, there are a few words which you will have to read. What is an affidavit? What is central act? What is government security? What is good faith? Important thing. I'm expecting a question on, write a short note on good faith. This was there in one of the attempts earlier where they had asked, write a short note on good faith. I will not be surprised if this comes up again. What is good faith? Anything which is done with diligence and reasonable care will be called as good faith. However, there is a court ruling, if you remember, Samsing Mupu and all of those. Do you remember? Yes. No, sir, we don't remember. That court ruling clearly says, sir, in case if you are negligent, just being honest is not sufficient. If you're negligent, just being honest is not sufficient. You will have to bring in diligence as well. If you're not having due care, then I will not consider it as done in good faith. Both the opinions are there. You will have to write both in your examination. Understood, everyone? We have discussed this during our sessions, if you remember. All right.
Yes.
Next. Here, Mong Ong Pu versus Mong Seep Mong. This is the case law. Do you remember? Yes, no, of course not. It's okay. Right now, we have just discussed. Official Gazette, we've seen whether what is applicable, what is the operation, when will an act come into operation. Section 5 says it is going to apply specifically. If the date has been mentioned in the act, it is going to apply from that date. If the date has not been mentioned, very, very important. If the date has not been specifically mentioned, it shall be implemented on the date when it receives the approval or assent of whom? Governor General or President, as the case may be. Governor General earlier, before 1950. I hope you remember the civics that we had discussed during our sessions. All right, where there's a possibility that at that point of time, I didn't have president. I had the concept of governor generals. In that case, they are going to give me the approvals. I hope I'm clear, everyone. Understanding? Yes. Next point. Effect of repeal. Moment an act is repealed. Classic example, Companies Act 1956. All right. The moment it is repealed, does it bring everything to an end? Answer is no. Whatever transaction, whatever arrangement, whatever debts are there under the old act, whatever penalties, whatever cases, litigations, everything will remain as it is. That will not come to an end. We have discussed this as well. All right. Then we went on to understand revival of the repealed enactment. Again, a classic example that I had given. 1956, repealed. 2013 is going on. Let's assume in next election, I don't know. This may or may not happen. I'm just giving an example for the purpose of merely our discussion. Let's assume the one who brought in 1956 Act, that party itself comes into picture. All right. Let's assume UPA comes into picture. Now, they say whatever you've done under 2013 and all, scrap that. Bring in 1956 again. What are we doing? Revival of the repealed enactment. Understood, everyone? Yes. Now, whenever there is a revival, first you will have to give the reason. Why are you even reviving it? Unless and until you give a valid reason, I will not allow you to do this. Understanding, everyone? Or else like this, there will be no certainty at all. Every day you keep changing everything that you want. Classic example, at one point of time, we used to have wealth tax. I'm sure you don't know. Income tax, you know?
Yes, sir.
Intermediate students I'm talking to.
Yes, sir.
Yes, sir.
So something similar, we had a concept of wealth tax. All right. There used to be another tax called as fringe benefit tax. there in your caps material, all right, where sir might have discussed what is tax. In that they would have given as a part of definition of tax what is fringe benefit as well. Now they've repealed that. Let's assume wealth tax is also repealed. After some time suddenly they arise and they're saying bring back wealth tax again. Now give the reason. Why do you want to revive a repealed enactment? I want the reason. Without reason you can't bring that back. Understood everyone? This is your revival of repealed enactment. Whenever there is any reference to the repealed enactment, you have to give the response. You have to give the corresponding section in the new act. What is the meaning of this? Let's assume I'm giving the reference to 1956 Act. You please read it as if it is 2013 Act. What is the corresponding section in 2013 Act? You please read accordingly. Understanding everyone? Yes, classic example. Again, your entire discussion in Income Tax Act is still having references to 1956 Act of Companies. In that case, you can't go and open Companies Act of 1956. What is the corresponding section in 2013? You have to read that. Understanding everyone? Yes, let's go ahead. Commencement and termination of time. The first day has to be excluded. The last day has to be included. Computation of time. Again, what all has to be included while you're considering the time whereby any legislation or act is directed or allowed to be done or taken in any court or offense on a certain date. If the court or office is closed on that date, the act shall be considered as done if it is done or taken on the next day afterwards on which the court is open. Classic example. You went to file your income tax return. Income tax office is closed. Why? They have gone on strike. Now, if you go ahead and file your returns on the next day, is it a valid return? 100% it is a valid return under 139(1). Understood everyone? Yes. Then measurement of distances. It has to be checked on a horizontal plane. Please don't write aerial and all that. It is not your agricultural income definition that we are talking about. You keep making parota in your papers, not required. Aerial is only in. I'm telling you, even after this, I know my students so well, they'll write aerial and come. Measurement of distance is on a straight line, in a straight line on a horizontal plane. Now that is possible only if it is aerially done, but that is your and my logic. Don't prove that in the paper. Section 11 never knew that there could be aeroplanes when it was drafted. I hope I'm clear, everyone. All right. Gender, at times, you know, I'll tell you, common sense, use common sense. When did this act come into picture? All right. At that time, did they imagine that we'll measure distance between Bangalore, Mysore aerially? Wow. If yes, let me know. Gender and number. Whenever it comes to gender, masculine includes feminine. Whenever it comes to singular, it includes your plural and vice versa. Construction of order issued under any enactment. Whenever there is any order, notification, circular, that has to be read in line with your act. That will derive its meaning from the act. Why? Act talks about what is the law. Rules, regulations, circulars, notification get the meaning or implementation. All the references have to still be from the act. You don't give independent meanings to it. It has to be read in line with your act. Understanding everyone? Yes. Next. Is the screen visible? Power to include includes power to rescind as well or make any changes. When I give you the power to include something, I'm also that power to include or issue also includes the power to make changes. Continuation of the orders issued under the enactment, repealed and reenacted. What is the meaning of this? Sir, whatever orders were passed under 1956 Act, 2013 came into picture. That got repealed. Now again, 1956 Act has been brought into picture. Whatever orders and notification, first order which were passed in 1987, 1989, 89, 1990, different orders, notifications, circulars which were issued, that will come into force again. Why? Because the act has also come into force. Understanding the logic, everyone? Yes. Then, very, very important, meaning of service by post under section 27. Latest intermediate attempt. There were 2 questions only on service of notice or how to send a notice. One was under the Companies Act. We have discussed that under section 20, if you remember, under your Companies Act. And now under your General Clauses Act, it is about 27. It has to be properly addressed. It has to be prepaid. Don't be conjures there. You have to make, don't show your miser thoughts there. All right. It has to be prepaid and posting by registered post only. This is the only reason why you send all the official communication to ICI through RPAD. I'm not sure how many of you have ever sent a notice or things to ICI. It usually is through your RPAD. What is RPAD? Registered Post Acknowledgement Due. Understanding everyone?
Yes.
Yes, sir.
All right.
Yes, sir.
Provision as to offenses punishable under 2 or more enactment. One mistake, one punishment. You can be tried under multiple laws, but you will be punished only under one law. This is the meaning under section 26. So what is the meaning of the word trial? Insist you to keep your cameras on. What is the meaning of the word trial? Trial means you will be checked. All your faults, defaults will be checked under different acts, different laws, but punishment can be only one. Classic example, at home, you've done a blunder. Your mom has told once, your dad has told once, your mom again told once. Before your dad opens his mouth the second time, you will tell, I can't listen to the same story again and again. I've accepted my mistake. What are you doing? Section 26. One mistake, one penalty. I hope I'm clear. Might sound lame, but this is how you remember the law. Interpretation of statute. All right. What is the meaning of the word interpretation? Interpretation comes into picture only when there is ambiguity. When the law is plain, clear, don't bring in interpretation. You are supposed to keep your cameras on. Sir, camera on for 5 minutes, switch off for 5 minutes, on for 5 minutes. Is that okay? Don't create ambiguity when it is certain and clear. I hope I'm clear. Still, people will not listen. Anyways, interpretation. It is the process of ascertaining the true meaning of the words used in the statute. This comes into picture only if there is ambiguity, only if there is confusion, or else there's no question of interpretation coming into picture. All right. Next, rules. There are two types of rules. One is called as primary rule. The second one is called as secondary rule. Obvious. Primary rule. First one, literal construction, also called as litera legis. Read the law the way it is. Don't add masala to it. It's not your Maggie. So please read the law the way it is. This is rule of literal construction. Second, rule of reasonable construction. There are possibilities by literal construction, it is not possible to carry out a particular provision of law or to implement it in force. In that case, you use your reasonable constructions. What would be ideal? What would be appropriate in a scenario? Accordingly, you're going to take your calls. The third one is rule of harmonious construction. As much as possible, as far as possible, ensure you read all the laws together and harmonize them. But in case if it is not possible, general or rather specific will override general. Latter will override former. Latter means whichever has come later on will override your formal law. Specific law will override your general law. We have taken a couple of examples of partners' introduction of capital as to the capital as land, if you remember. There in the session? No, we haven't discussed.
Yes, sir.
Yes.
Yes, sir.
Rule of beneficial construction. Rule of beneficial construction is also called as Hayden's rule. Don't forget. All right, not Turquin's rule. Now this is the problem. Suddenly you will get my mistake. I shouldn't. You anyways didn't remember Turquin's rule. I'm sorry. I'm sorry. All right. Most of you thinking, sir, we didn't even remember. Why are you even bringing it? Turquin's rule is doctrine of indoor management. Hayden's rule is the mischief rule or the rule of beneficial construction. You cannot read the law for the purpose of committing a mischief. If you're doing anything of that sort, then law has to be read in such a way that this mischief is condemned. I hope I'm clear, everyone. Mischief will not be allowed. Classic example, bending the law without breaking it. Tax evasion, or this is what you might have come across. All right, what is it? I'm sorry. Tax evasion is
avoidance.
Tax avoidance. I'm sorry. Tax avoidance. Yes, classic example which sir often gives. Tax evasion, you don't wear the helmet, you know you're not going to wear the helmet. You'll take caught and it's a straight case. You'll wear that helmet as much as it can cover the first few hair of your head. Helmet, no, not allowed. I hope I'm clear. All right, what is this? Rule of beneficial construction. I hope I'm clear, everyone. All right, might sound lame, but extremely important. Rule of exceptional construction. There are scenarios where you will have to exceptionally read law. May might have to be interpreted as shall. Second, and has to be interpreted as or, and or has to be interpreted as and. Classic example, section 2, clause 85. Small company definition. Although people took it for their convenience, but ideally, rule of exceptional construction should have been applied at that point of time. People didn't, it's okay. Rule of aegistem generis. The words derive the meaning. The general words derive their meaning from the predecessor words. Example, lion, tiger, etc. The word etc. derives its meaning from lion, tiger. This is called as rule of aegistem generis. please expect one of the rules in examination. Recently, latest attempt, there was one 4-marker from this primary rules. All right. Those of you who have written your examination, you might be able to connect with whatever we are talking about. All right. Second one, secondary usage or secondary rules. First one, effect of usages. Whenever you're using words, you have to use it in such a way that there is a meaning attached to it. All right. Second thing, associated words should be understood in common sense manner. Whenever there are a few words which are used in between two words, example, cosmetics, perfumery. Do you remember? All right. The word perfumery cannot include your industrial perfumes. Why? Because I'm using it with cosmetics. I'm using the same example, friends. I'm not even changing my examples. All right. Just to ensure that you guys are able to recollect. We've seen the primary rules. We've seen others. Now coming to your secondary rules. The first one, expressio unius est exclusio alterius. Easy to remember. Expressly, if I'm mentioning one, I am excluding all the alternatives. Example, land, coal mine, etc. Now, can this etc. include your gold mines? Or rather, let me give it this example itself. This was the example, if I'm not wrong. There's land, there's coal mines. All right. And they might have used some other words. Now, you are saying that, let's assume gold mines. Gold mines is included in the land, so please cover it. No, you can't. Express mention of one excludes all the alternatives. Understanding, friends, everyone? Yes. Next one.
Yes.
Next one. There in the session, sleepy.
No,
No,
sir.
No, sir.
Sir.
We are in
Because you're-
session, not sleep.
There in the session.
There in the session, sir.
All right. Nocedere sauces. What is the meaning of this? Construction of associated words. Whenever there are words, all right, they derive the meaning from their associated words. Classic example, just now I've given perfumery. All right, cannot include your industrial perfumes. It has to be, it will derive the word meaning of it from cosmetics. Are you guys understanding? Yes. Then contemporaneous expositio. Whenever you're reading law, all right, you have to assume at that point of time what was the position. Based on that, how the law was driven. At the same time, whenever you're reading law, it cannot be only the law, only the act that you're going to read. You have to read the corresponding circulars, rules, regulations, everything together, and then come to a conclusion. It can't be only based on act that you, I'm sorry. It can't be based on only the act that you come to a conclusion. Understanding, everyone? Internal aids to the interpretation. Expect a question. Expect a question. All right. They ask you to write a short note on what is preamble. Write a short note on what is a title. Write a short note on what is a marginal note. So to quickly explain title of any of the act, there are two titles. One long title, other one short title. If you remember, I've given an example of Sarfacy Act. Do you remember?
Yes.
sir.
All right.
Sir.
The name itself is huge that it will not fit in one line. So to make it easier, the long title is whatever it is, securitization and blah, 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 blah. The shorter title is called a Sarfacy. I hope I'm clear, everyone. All right. So there are two titles. Companies Act. The shorter title is Act. If you go read the Act, most of the sections use the language Act. Which Act? This Act only they are referring. I hope I'm clear, everyone. All right. Second point. Preamble. We, the people of India, Constitution ka preamble. Do you remember? Yes. What is that? To give the objective of the entire act. Why is this legislation even coming to picture? Classic example. Companies Act. Do you remember the preamble? To consolidate all the acts. All right. And for all the corporate purposes, whatever different acts are there, we're going to consolidate. And that will be called as the Companies Act. Do you remember? We had discussed this. We've seen it practically.
Yes.
Heading and title of
Yes,
every chapter. If you remember, your entire Companies Act is divided into multiple chapters. So there is a heading attached to it. Does it add value? 100%. It gives me idea of what exactly all these sections are pertaining to. Example, incorporation of companies. So whatever sections are detailed there are all going to be pertaining to incorporation. Audit and auditors. All the sections there are going to be pertaining to your audit mechanisms and audit procedures. Understanding, everyone? Yes. Next, marginal notes. Right next to the left side or right side, you have some tiny phrases written. That is called as the marginal note. It gives me an idea of what exactly this section is about. Can I use this for interpretation? Yes, you may. Yes, you may. All right. Definitional clauses. Most of the definitions are coming under section 2. All right. Whatever definitions you're going to refer, if it is under section 2, most of the times, not always, I repeat, most of the times, not always. Classic example, negotiable instrument. Just now, Partnership Act, another one. All right. Section 4 defines partnership, if you remember. So definitions usually are under section 2. This is given to avoid ambiguity throughout the act. The moment I use the word person, what is person under Income Tax Act? Go to section 2. All right. You're going to get exact definition of it, which can be applied throughout the act. I hope I'm clear, everyone. Illustrations. These are ideas or these are examples which you can use for the purpose of understanding a concept. Classic example, depreciation, how to be calculated is given in schedule 2. Another, standards on auditing have a few illustrations. I think I discussed this as well. All right. Standards on auditing, how to make an audit report. They've given a few illustrations that
Yes,
can
sir.
be used for the purpose of your references. Proviso. Proviso creates an exception. Whenever I want to create an exception, I carve out through the proviso. Classic example, section 2, clause 71. Public company means a company which is not a private company. Proviso. If you are a subsidiary of a company which is not a private company, although by your articles of association, you might be a private company. However, for the purpose of this act, you will be deemed to be a public company. Do you remember? Deemed public company
Yes, sir.
definition is
Yeah.
what we are talking about. Next, explanations. Explanations talk about clarity. It gives clarity to the sections. Example, when I say equity shares, preference shares, what is the meaning of this? Explanation to section 43 of your Companies Act gives the definition of what is equity share, what is preference share. You're going to refer it for the purpose of clarity. All right. Then schedules. Schedules are your birthrights, formats, copy. When it comes to your entire Companies Act, there are 7 schedules, which is giving you various formats for various aspects. You can use that for the purpose of your understanding. All right. Next, without prejudice, 3 words. Expect any of these in your examination. Expect one of these 100%, not this attempt, immediately preceding attempt. Before this, there was a question on, if I'm not wrong, on without prejudice too. If I'm not wrong, there was a question on without prejudice too. All right. So what is without prejudice? First, let's understand notwithstanding. Notwithstanding means I don't care what is given anywhere else. What I'm going to tell now is going to be effective. I don't care whatever is there outside or in anything else. This law is going to override all the other laws. That is called as notwithstanding. What is the meaning of the word without prejudice? Without prejudice, even before I get on to without prejudice, rather, let's go to subject to. Notwithstanding means I don't care whatever is given anywhere else. This is going to override everything else. What is the meaning of the word subject to? This law is subject to the provisions of other law. This law, whatever we are going to discuss, is dependent on the law which is somewhere else. So classic example, if I'm saying notwithstanding in this section, section A, notwithstanding what is given in section B, all right, if I'm saying in section A, section 1, if I'm saying notwithstanding what is given in subsection 2 would be subject to subsection 1. Did you understand? No, we didn't understand. No problem. There are 2 subsections. Subsection 1, I'm saying notwithstanding what is given in subsection 2. That means 1 is going to override 2. For the purpose of 2, it is as good as subject to what is given in 1. As simple as that. Understood, everyone? Yes. If 1 says you have to do A, then even 2 is saying subject to what is given in subsection 1. You please follow that. If that is being followed, you also consider this. Notwithstanding means I don't care what is given anywhere else. I will do what I have to do. Just like you guys. All right. Notwithstanding people around. Simple example. And the last one is without prejudice. What is the meaning of the word? What is the meaning of the word without prejudice? Without prejudice means, sir, let's assume I am saying all boys and girls have to attend the session. This is the general statement. Without prejudice to this, without prejudice to the possibility of you guys not attending the session, if you think you will not be able to attend the session, that will stay, sir. That I'm not going to change. All boys and girls have to attend the session. Without prejudice to this statement, I also suggest after the session, please stay for 10 minutes for extra gyan. So what is the meaning of this? Sir, that will stay. That will continue as it is. That will not be changed. Now, you can't take an interpretation that he's asking me to stay only for 10 minutes after the session. No, that's not what I'm meaning. I am saying without prejudice to whatever I told, that will stay. Along with that, that is not being disputed. That will stay as it is. Along with that, please remember, this is also an additional factor which I want you to remember. Understood, everyone? Yes, let's quickly read the law. Now, just writing this, you will not get the marks for writing whatever I've given an example for. Expression containing without prejudice indicates that anything contained in the provision following such words is not intended to cut down the generality. The same thing we are doing. When I'm saying all boys and girls have to attend the session, it's the general statement that I'm doing. Without prejudice, if time permits, please stay for 10 minutes after the session. What is the meaning of this? Generality is not being cut down. That has to be followed. But apart from that, in addition to that, please ensure that you are also going to stay for 10 minutes. Understood? 3 words. Without prejudice to, notwithstanding, subject to. Crystal clear with the concept, everyone? Yes.
Yes.
I think that's more or less about it, because amendments, whatever were there in the last session itself, I had already discussed the amendments, all right, where we have seen in length and breadth. Now, what we're going to do is, let me know if the screen is visible.
Yes.
Just give me a second. Is it visible now?
No,
No, sir. No, sir.
Sir.
Wait, just give me a second. Yes. Visible?
no.
So I'm just showing the presentation of quickly the entire syllabus as such, so that you get a hang of it, because we've already discussed, and I don't think we have the enough time to cover the entire syllabus once for all. Let me know if the screen is visible now.
Yes.
Yes, sir.
So goes unsaid, we've revised the entire Companies Act in the last revision. In today's session, we have covered 3 chapters of your allied laws. All right, that's almost 30%, or rather, I would say 30 marks of your 40 marks. If you ask me, out of your 40 marks, based on the weightage, if you see 20 to 35%, 15 to 25%, and 15%. So effectively, if you see 50% is already covered. So minimum 20 marks we have revised in today's 1 hour. The rest was discussed in the last session, where we spent 2-3 hours together and we've looked into it. Now, how do you approach this subject? First thing, please pay attention on what I'm talking. If you were not attentive in the last 1 hour, I don't care. Now, whatever I'm going to discuss, please pay attention. First thing, please note, allied laws cannot be ignored. 40 marks at a stretch coming from 4 simple chapters. Ensure that you know word by word of the entire study material. There's no substitute. Goes unsaid, I can't make the CAPS material a copy paste of study material. It will not serve any purpose. It has to give you only a quick summary of the syllabus. So if you are with the thought that just reading CAPS material will be sufficient, maybe, may not be. All right. If you ask me to get 40, 100% more than enough. But if your target is only 40, then trust me, you will not get 40. It's as simple as that. All right. Just to get 40, is it sufficient? 100% it is sufficient. But if your target itself is 40, trust me, you will not get 40. This is intermediate, where people write for 100 marks, still not confident of even getting 30. Where your target itself is 40, I don't know how it will work out. Read the study material. There's no alternative. First thing, how do you approach this? Sir, please don't read entire Companies Act at one stretch and then read the entire allied law at one stretch. You will end up doing a futile exercise of wasting time. It will not fetch anything, because it will get too monotonous and you might not be able to remember everything, because you'll need a break. Go by the approach that we have taken during our sessions. Read 1 or 2 chapters, or rather I would say 3 chapters of company law, or go by the buckets which are there in the syllabus. Finish a bucket, switch immediately to allied law. Finish a bucket, switch immediately to allied law. Don't search for shortcuts. You will have to read the study material. Important thing that you will have to remember, friends, is examples which are there in your study material. All right. Most of the examples we have discussed during the sessions itself. Most of the examples we would have taken up during our classes itself, where we would have discussed in length and breadth. But there might be few additional examples as well. Ensure you read those examples. There's a high possibility that ICI might want to just check, are you reading the study material or you're still following some shortcuts? What they have to do is just take one of the examples, which is the trickiest one, and place it in the paper to check if you've read the study material. It might be a simple point running around one particular word, and you might not be able to catch it until and unless you spend time on the study material. Read it. Read it. Ensure you spend some time on the examples, illustrations solved in every chapter. Every chapter has that. Every chapter has illustrations and examples in your study material for law. I'm specifically talking about law. Special focus required. All right. I'm not saying the only chapters where you have to read, or I'm not saying these are the only chapters which will be enough for your law. No, I'm saying special focus required, extra attention required. Everything you're reading once, absolutely fine. Read these chapters twice. First one, prospectus, share capital. You have no alternative. You have to read these chapters twice. All right. Note, this does not mean that I'm indicating not to read the first two chapters. Don't take it otherwise. If your interpretation is wrong, that's your problem. It is not my problem, because just now we've learned how to read law. I repeat, don't conveniently understand what I'm saying. It is your attempt, 6 months at stake. What I'm saying is pay extra attention on these two chapters. In the preceding attempt, when I was doing this question paper analysis, I realized that plethora of questions have been asked from share capital and debentures. Now, this one chapter has already been covered in accounts group 1, group 2. At the same time, in law as well, we have covered this. If you remember, we have discussed all those topics which are not there anywhere else. We've discussed in law. All right. Now, pay extra attention on this. It was observed that while I was just reviewing the, while I was just going through the question paper of last attempt, they've asked questions from those areas which we think is useless, which we think most of the time, hey, no one is going to ask questions from here. This is not even relevant. Those are the areas where they are going to ask questions. I remember gladly in the last batch, I'd mentioned, please read the service of post, how they send post, all that is important. All right. 4 marks of how to send post had come in this attempt. Specifically, I discussed during the classes. Please pay attention on this post. How are posts being sent under Companies Act as well as under your General Clauses Act? This was one of the areas which student might have just conveniently ignored. Who is going to ask about how to send a post? And that was the question in examination. When it comes to second bucket, all the 3 chapters are 100% important, but goes unsaid. Management and administration don't enter the examination hall itself. Don't write this paper itself if you don't read this chapter. Because the entire chapter is revolving around the main aspects of companies' procedures. Right from your registers, how to maintain a register, till the resolution. What type of resolution has to be passed? What are you going to do? When are you going to do? What is the time frame? All this is covered here. Are you guys understanding? Now, again, surprisingly, in this attempt also, if I'm not wrong, there was one question revolving around special resolution. How a special resolution is to be passed, or some question. I'm just not able to recall what exactly that question was. Trust me, the same discussion we had during our sessions. Same discussion we had during our sessions. I'm not sure students would have enjoyed writing that answer or not, but definitely I enjoyed reading that question, because the question and the example that was quoted was just the same that we had discussed during the sessions. All right. Next, declaration of dividend, accounts and auditors. Note, audit and auditors cannot be ignored. Just because during a session we have relied on what has been done in auditing syllabus does not mean that you're going to ignore this chapter. This is another huge problem which I'm just trying to figure out what is to be done, because students assume that they will not ask questions on audit and auditors in corporate law. They'll ask in auditing and they'll not read the chapter. Close to 8 to 10 marks in the latest attempt were revolving around audit and auditors. Chiller topic. All that you had to do is, while you were reading auditing, you should have read this chapter together, and you're done with your task. You're done with your subject. Are you guys understanding, everyone? Yes. So
Yes.
please ensure you read audit and auditors carefully. Goes unsaid. Accounts, one of the most important topics. Section 128 onwards till section 138. Extremely critical sections. Read it. All right. What is books of account, how it is to be maintained. Internal audit, this time I'm expecting a question. All right. I'm expecting a question on CSR. I'm expecting a question on internal audit. These two are extremely important topics. Now, doesn't mean that I'm predicting question papers. This is not Dream 11. This is not your MPL. This is just a possibility because of the amendments which have come in. All right. This is just the possibility that we are talking about. I hope I'm clear, everyone. Understood? Yes.
Yes.
Now, how to approach this paper, how to read this law. I'm extremely sorry. I might end up extending by another 5-10 minutes, but I hope that's cool.
Yes.
Yes, sir.
So, guys, when you're reading study material, I will just quickly show this is the approach that I have been following throughout my life when it comes to theory papers, and God's grace, it has helped for me. It has worked for me. Let's assume this is your paragraph. All right. Let's assume they haven't given all this. They haven't given any of this. They've just given the paragraph. Are you guys understanding? Now, it's your responsibility to ensure that you read this entire paragraph once. Make one sentence right next to it. Just write one sentence next to it, or probably a phrase explaining the entire paragraph. Why? Because it saves time while revising. How I approach theory papers, something again very personal. You might have your own approaches, but this is what I personally do often. Let's assume this is the entire chapter. I'm going to spend first 15 minutes only on skimming through the subtopics. Just spend 15 minutes. What all is there in this chapter? I might be aware. I know what is there, but still I will spend 15 minutes, first 15 minutes only on reading what all is there in this chapter. Then I carry out my regular reading. However you regularly read, you please carry out word by word. However you carry out, however you do, please go by it. After you're done, let's assume you spend 4 hours on that. After your 4 hours, spend another 15 minutes in quickly going through whatever you've written in the lefts or rights. Whatever those marginal notes you've made, just read those. Just read those. Trust me, 3 times, same topic you've already seen. How on earth can you ever complain that you're not able to recall stuff? Because you are waiting for a revision after 1 month. Why? You do it right away. Do it right away. And how much time are you spending? 15 minutes, extra 30 minutes if you ask me. But this will save almost 2 to 3 hours during your revision, because you've already seen, you've revisited it during the immediate period itself, and this is going to help. First thing, most of you have this problem saying, sir, theory papers, I find it difficult. Practical, I can solve any number of problems. Theory, I can't read. Get out of this notion that that is a theory paper. I was asked to teach a practical paper. I chose theory because I knew I can make a theory paper to practical. If you see, I have never given any high funda examples whenever I was discussing. It could be a lame, stupid, simple example right revolving next to your lives. Do that whenever you're reading any theory paper. All right. First thing, stop thinking that it is theory. Second thing, whenever you think it is dry, there's a possibility that it might go dry. In that case, add examples, add a few elements of your things which you can easily remember. I don't have to talk about Chota Beam Private Limited. The moment I talk about this, there's an answer which is coming in your example. What is it pertaining to? Anyone?
Limited liability.
Limited liability.
The moment I talk about Tom Private Limited, I don't have to talk about
Something
anything,
of
because the
corporate
first
wealth.
thing which
Of
hits you,
corporate will.
the moment I talk about Abhimanyu, I don't have to talk about anything in
Older
detail,
and
because you know,
Of course.
this is the beauty. Whenever there is something which is absolutely dry, add in an element of something which is there right next to you. You will remember. You will definitely remember. I do this. Trust me, when I'm reading law right now, when I'm pursuing my LLB, and I have LLB supposed to be only with theoretical papers only. I don't have accounts in LLB. All right. I genuinely bring in these kind of examples because I have no option. It is what it is. All right. Now I have to bring in something to ensure that it gets a little more exciting, a little more interesting, and I have to remember above all. That's when Chota Beam suddenly comes into picture. That's when suddenly Tom Private Limited comes into picture. Are you guys understanding? Do this. Because for law, as much as possible, I've given you those kind of examples to ensure that you will remember. For other subjects, if it is not available, please do it for yourself. Don't wait for someone. Most important thing, whenever you know a paper is creating a little bit of issue for you, ensure you write as many mock papers as possible. All right. Let's assume theory. Let's assume law is one of those. Ensure you write at least 1 extra mock paper. For others, you might be writing 2. Ensure you write 3 for this. The more the time you spend with it, the easier it would get. The more the time you spend with it, the easier it would get. Last thing, ensure in the last page, whenever you're reading any law or any theoretical paper for that matter, ensure you make a list of all the section titles and section numbers, something that we would have done during our sessions. All right. If you would have done then, you will save hours together now. If you weren't doing it, now you will have to spend time on updating your list. No option. All right. A stitch in time saves 9. As simple as that. All right. You should have done it at that point of time. You did. Now you might have to spend time, but ensure you have this list, because one day or 1 hour, or maybe that morning of the examination, you'll at least have that 1 hour where you can quickly skim through the entire syllabus in 2 pages. Because knowing the section title is more than enough. You will be able to grasp the entire topic there. Somewhere you will be able to relate at least. Worst case, you're not able to remember anything. The question is on internal audit. Just write the section number at least and come back home. That at least you'll be able to remember, right? Worst case, I'm not asking you guys to go with this approach, but I'm talking about the worst scenarios. I hope I'm clear, everyone. The moment I talk about MGT, the moment I talk about special resolution, there should be something which should strike immediately 14.
MGT 14.
Just now I mentioned MGT 14. All right. So there are simple ways of getting those extra creamy points. It's easy. Approach the paper just like another exam, just like civics you might have approached 8th, 9th, 10th. You never thought, what if I fail in civics? No one ever thought, what if I fail in 10th? If you did, seriously, I have some doubts. If you didn't, just approach the same intermediate also with the same pattern, you will clear it 100%. It is a doable task. Nothing I found out. Blind people have done it. People who have multiple reasons for not doing something have done it. You find one big reason why you would have to do it. Apart from that, one last thing. Ensure you read 2 or 3 RTPs at least. If you ask me, 3 RTPs including your RTP, or 2 RTPs excluding your RTP. 3 RTPs you will have to read, including your RTP. Questions might come from those. Why? ICI might want to just check. I've posted so many things. Do people even open and see? Let's ask them in examination. Let's check if they are opening or not. There is a high possibility they might do this. Ensure you solve at least 1 mock paper. If you find this paper to be a little tricky, ensure that you solve at least 2 mock papers. Who is going to correct? That's a secondary aspect, because writing mock papers is not to ensure that you get marks. The whole aspect of writing mock papers is to learn how to manage 3 hours. A 4-marker question cannot be given more than 6 minutes or 8 minutes. If you're giving more than that, that means you'll come back home complaining that I knew everything, but I was not able to finish paper. And that is the biggest stupidity. It is a scenario where you have the gold in your hand, but you're saying that I don't want to use it and I prefer being poor. Why? Because you couldn't manage stuff properly. You know the paper, you know the answer, but coming home back with the statement that I couldn't complete the paper is the biggest crime, if you ask me, which you're doing it to yourself, no one else. Because had it been a paper where you don't know, I can understand. You know, but still you're not able to pick up the pace, then it is all because of your laziness. You haven't written all the time on keyboards and probably on your phones. And the only thing which you have done is probably scribbling 1 or 2 papers while your classes were going on. It is something that you are lacking. You cannot give this as a reason. My friends who have written your attempt, you will vouch for it, that you might have come out and told, I couldn't finish the paper even though I knew it. This is the biggest problem. Ensure you write 1 page every day. Even today, when I know my examinations are after 15 days, 20 days, I ensure I scribble 1 page at least every day, because I can't sit and complain thinking that it's been ages since I wrote papers. No, it can't be so. I hope I'm clear, everyone. Understanding? Yes. There are amendments in the latest update. There are a few amendments. Ensure you know each and every amendment which is there in your amendment material. I will not be surprised if questions are picked from there. And if you see, majority of the amendments are on CSR. Majority of the amendments are on CSR. Last session, I'd spent almost half an hour only on the amendments. All right, on CSR specifically, what all has happened, what all are the things that you will have to remember. Ensure you read the amendments carefully. Extremely critical. May attempts are usually on amendments. May attempts are usually on amendments, because this will be the immediate or the first attempt where they can quickly ask on amendments. One last thing, probably I'll be done with this. There are 1,000 reasons for not doing something. Ask yourself that one reason, which is more than enough to push. I still remember there were days where people used to come up with reasons that, sir, I'm not able to read, I get headache and all of that. Guys, if you can't stay sane physically, mentally, then something you're doing to yourself. There's something which you're doing inappropriate, and that is causing damage to yourself. Stay sane. The only way to do that is, I know it is outdated, but still relevant in today's generation as well. 2, your course of yoga, meditation, please go out and play for at least half an hour. That is an investment. People think you're wasting time, but you know you're investing time for the next 8 hours, 10 hours that you need throughout the day. All right. Don't take this as wastage of time. Even if it is waste of time, it's okay. You get your breaks. I often prefer this. Study for 55 minutes, take a break of 5 minutes. Study for 55 minutes, take a break of 5 minutes. This is again a 5 minutes investment for the next 55 minutes. At a stretch for 3 hours, 4 hours, if you study, there's a huge amount of heat generated and you can feel it. I don't have to tell that. You can feel it. Whose foolishness? Your foolishness. Take appropriate breaks. Ensure that 5 does not become 50 and 50 does not become 5. I hope you realize the proportion that we are talking about. All right. You have to get into your own zones then. I hope I've done a fair job. We've spent 1 hour. All right. In revising whatever we could in this last 1 hour. And in the previous session, again, we've revised a couple of important topics. I would definitely be meeting you guys once again before your examinations. And till then, work hard. If there's no madness, there's no fun. I'm not sure how many of you were there in the morning session. Probably my energy was as much as it is now. All right. Or rather, whatever was my energy in the morning is the same energy now. All right. It is just sheer madness that I have when I attend the sessions. Because I know this 1 hour is an investment for me. I don't care about anyone else. I want to enjoy this. So enjoy whatever you guys are doing. Often people ask me, why do you want to yell at the top of your voice, even in the evenings, mornings? Guys, this is my madness. I enjoy doing it. Whether anyone else likes it or not, I don't care. I am enjoying it. I want to continue. The same time, you figure out where's your madness. The only madness should lead to your intermediate results as pass and pass. That's the only madness everyone is seeking. All right. With this, I come to an end. If you have something to share, please raise your hands. Go ahead, or else we can wrap up the session. That's it. Be good. Great. All the very best, friends. Have a great time. Enjoy reading. Spend some time. Whenever you find a particular topic is getting dry, bring in your elements of livelihood. Bring in your elements of life. Wherever you find fun around. It could be a cartoon series. It could be a character on Instagram. It could be a meme which you might have come across. It could be anything. Connect that. Bring that in your books. You will remember. Write it down right next to it. It could be a stupid story which your parents might have told. It could be a stupid lame incident which you might have come across. Write that incident, connect it, relate it to the law which you're reading. You will remember it. No one on earth can ever do anything to make you forget it because you are going to remember it. You have related it with things happening around you. As simple as that. All right. With this, I wrap up. Thank you so much. Good night, friends. Let's catch up soon. All the very best.
So much.
Thank you, sir.
Thank you, sir.
Thank you, sir.
Sir.
Thanks, sir.